You're live.
Okay, welcome folks. This is House Corrections and Institutions. It's Friday. April 17th, and this is our quarter-of-9 meeting. Before we go to the floor, we're continuing our conversation with the Department of Mental Health on S-193. And thank you folks for accommodating our schedule. I know that this is Friday and it's the school vacations coming up, so there's other priorities coming in, but we're going to start with Karen Barber, who is with DMH, and we have some other folks here in the room as well. So Karen, let me turn it over to you.
Sure, thank you. So good morning. For the record, my name is Karen Barber. I'm General Counsel for the Department of Mental Health. I apologize for being remote, not in the state today, but happy to be here with you.
You just look normal.
Can't help the digs, huh?
Yeah.
I was able to listen to the past few days of testimony, so I wanted to clarify some of the issues I heard and then jump into some specific points. And please, as always, feel free to interrupt me at any time and ask questions. And VSH was a topic of conversation yesterday, so I wanted to clarify some information around that. And it's essentially what Chairman said yesterday. So VSH was never a forensic facility. It was always a hospital. The population we are contemplating in this bill was not served at VSH. However, just like now, we do have folks that are served in the hospital system that would be considered quote unquote forensic. But it is based on their clinical need, not a placement need. There has always been a gap. There's never been any sort of forensic system in Vermont. And I think, again, what Chairman said yesterday, what we're seeing is frankly just an increase in these high-level crimes. I think if you had looked at the newspapers and heard from people back then, you would have heard some of the same complaints. But certainly, I think what we're seeing is the impact of substance use on the state. We're seeing, we're just seeing more of these things, and so I think that's part of why it seems bigger right now. I think, you know, VSH is a bit of a red herring. I think it's easy to kind of say, oh, everything was great when we had VSH, but it actually wasn't, right? VSH, as you guys talked about yesterday, was decertified. It wasn't, you know, towards the end, we did need some changes in our system. We did go to a decentralized system, right? So we do have a smaller quote unquote state hospital, but that's because you, as the legislature, made a decision to decentralize the hospitalized system. So there are 6 hospitals across the state who take individuals on an involuntary basis. And so instead of having one location, they are spread out. I do just want to note that it is more, even though we were decertified, it didn't mean so part of our hospital license is that you're making some high clinical. Can you hear me now? Okay.
Chopping up what you were saying, even though it was decertified, then you really got chopped up.
You turned off that's
okay.
That's
I'm
good.
going to turn off my video and see if that helps. Is that okay?
It does. Much better.
Okay. So even without having our CMS certification, we were still required to have a hospital license just like now. And hospital licensing criteria is linked to CMS clinical criteria. So again, CMS isn't just all about money. It's really about quality and oversight. And CMS certification is more than just about getting Medicaid, because if you're not CMS certified, you also can't get Medicare or use private insurance. So it's not as simple as just saying, just because we were decertified, we could all of a sudden take individuals. It's a much more nuanced kind of clinical criteria that we're talking about.
So Karen, the big shift that happened when the old state hospital was decertified was that the operations of the hospital really ended up being funded totally by the state general fund instead of having Medicaid dollars coming in for those beds. Is that correct?
Yes, it didn't change the function of the hospital, it just changed the payment structure of the hospital.
So it was a hit to our general fund.
Yes. And so just like now, VPCH and River Valley, I know we've talked about those a little bit. Those are mental health facilities. They don't have the expertise, the staffing, they're not designed to serve the population we're talking about. And I just really want to stress that you don't create a gap in one system by creating a much larger and more impactful statewide gap in another system. If you wanted to try to take those facilities and use them for this, you'd really have to take them offline because you're talking about very different programming and very different people. And really kind of gut them and use them for something different, which would create real gaps in our system. Um, I also heard some questions about why now, why all of a sudden are we bringing this up? And I wanted to stress that the administration has been pushing for a forensic facility for over a decade. I personally have been doing it my whole career at the state, which started in 2014. And you've seen us bring to you multiple proposals over the years. At one point under Secretary Al-Gobay, we proposed a campus model, which is more similar to other states. And it would have been both a forensic hospital, forensic residential, outpatient. It would have been a whole system. And it would have been much broader, right? So the way we talked about it was anyone coming in through the criminal justice system would be served in this facility. And I know I spent a lot of time in this committee talking about that campus model and the big F and the little f. That was not something that got a lot of traction. Then we had a group several years ago that went all around the state. It was Human Services, Public Safety, BGS was there, and we looked at facilities all over the state to look at options for forensic facilities. Again, that was something that wasn't something the legislature was inclined to do. I mean, of course, those are policy decisions that you can make and have made. I just want to be clear that this isn't something new that we're bringing to you. It is something that we have brought over the years. What we've tried to do this year is really take a lot of that feedback that we got, which was that it was too broad, it was too many people, it was too big, you didn't want to build a whole new thing, and really think about what is the biggest, most impactful gap? What are we really seeing impact public safety? And so that is why what we brought to you this year was a very, very narrow proposal, only for crimes that are the most heinous, really murder, right? And so we really tried to focus on a very small population, on making sure that it wasn't just about restoring competency, but it was linking to clinical needs, that it fully addressed the gap so that it wasn't just mental health, it wasn't just intellectual developmental disabilities, but again, included folks that we are seeing currently that are public safety risks, such as substance use disorder, TBI, dementia. And so really tried to narrowly tailor something in front of you based on kind of the years of feedback we've gotten from the legislature, which was we were looking at too big of programs. I think the reality is not everyone can be served in the community. That's just a fact. We try and always strive for the least restrictive settings that's required under this bill. And public safety is a real issue. And so we are trying to address that in the narrowest way possible. I also heard you all talk yesterday about a feasibility study. And I would urge against that, and it's because we've done that already. So the legislature asked for this, almost word for word, kind of what you were talking about yesterday in Act 57 of 2022, Section 6. And so that was a huge group of stakeholders from all across the spectrum. There were state agencies, the Defender General, states attorneys, legal aids, DRVT, victims' rights groups, all included in this. The legislature did allocate us $25,000, which was unfortunately nowhere near the amount we needed to actually get a consultant. We put out several different RFPs. No one responded. We kept trying to narrow the scope of what we were asking for. And in the end, Samantha Sweet, who's now the deputy commissioner at DMH, and I did the work. We did it over 18 months. We attempted to have outside people come in and do presentations. We had someone from the Connecticut Psychiatric Review Board come. We tried to present data and different papers we could find. In the end, nothing came out of that work. No one could agree on literally anything. And so what we presented to the legislature was a report saying that and giving everyone's opinions about what they thought would work. And the legislature didn't take any action on that report. So I would just urge against trying to do that again because we have already done it. And I think that, there is a real gap in the system. And if we don't do anything, if you let perfect get in the way of us making steps towards progress on that, I think that there's still public safety risks, and we are concerned about that. If you do go forward with this, because of course it's a policy that you are certainly entitled to make, I would encourage you to think about what actual funding would be required, and to not exclude entities that are doing the work. I know there's this idea that maybe we shouldn't be the ones doing the work, but I'm concerned that if you exclude the folks that are going to do the work, you're going to waste a bunch of time and money and creating options that aren't actually feasible for us. So I just kind of wanted to cover that. There was also a lot of talk about needing a separate facility. So I wanted to remind the committee that that's actually something that already must be considered as part of the interim report. It's not a new idea, right? The Senate spent some time talking about this and wondering about whether or not a separate facility was needed. And what we said then and what we continue to say now is we are asking you not to tie our hands before we've had a chance to actually come to you with a proposal and think through as an agency what makes sense. Again, we're talking about a very small group of people. What we don't want is to isolate people or cut people off from opportunities. And so we haven't had a chance to really think about that. And so it is already a requirement that we consider it. And we do think that that meets your needs. I want to acknowledge that you heard some initial thoughts from DOC, but that's not the final AHS report. AHS as a whole has not come together to really discuss the issue and come up with proposals, and much of that work still remains. Your questions are all really important and valid. We just really need time to answer them, and we can't answer them without knowing the population. And I said this the other day, but I want to say it again because I think it's important. If we had come up with a whole proposal this summer, it now wouldn't be helpful to you because the bill has changed so much. And so what we're trying to do is to say, give us some guardrails, tell us who you want us to serve, give us some details about that, and then we will create the program. And then you still have time to weigh in. The program wouldn't go forward unless you approved it, but we can't really design it and answer your questions until we know what we're doing. The bill doesn't even go into effect, these provisions, until 2028, meaning you'll have all of next session to look at this and decide if you want to pull the language or make modifications. So we would really ask that you give us time and flexibility to determine to make proposals that we think are the best interests. Of course, you can not take those, but to tie our hands before we've even have an opportunity, I think is a misstep. So those are the things that I heard in testimony. I was going to talk a little bit now about what happens right now, but is there anything I missed or you want me to touch on before I go forward?
Well, I really appreciate what you just mentioned about AHS is now coming together. Everyone, I'm assuming commissioners of all the departments.
Yes.
Are coming together and that you want time for this to play out, but you are looking to us for some guardrails, and give you some time to develop the program, and for us also to give you time and flexibility for that. So the bill, as beginning July 1st of this year, asked the Commissioner of Corrections in consultation with some other folks in the Agency of Human Services to start promulgating rules. Isn't that a little ahead of the game to go ahead and promulgate rules?
So I think, as you spoke about yesterday, Chairman, it takes such a long time to get rules that I think the idea is that we start the rulemaking process, and I believe the report talks about providing an update on how we're doing with drafting. So we think because it takes so long to promulgate rules, we need to start thinking about them. But certainly it's not the end all be all, or there will be opportunity for the legislature to weigh in. I don't anticipate that we would have rules done by next session, even just to put them before LCAR, because it will take us a while to draft them because they're really specific and we need to really put a lot of time and thought and effort into them.
Yes, rules are specific. The administrative rules carry out the intent of the law. And we don't have the law in place in terms of what that forensic facility will be or where. We have a definition of it. But I'm finding that that's the cart before the horse in terms of doing rulemaking, and you don't know what the final product is gonna be of what you're gonna have the rules apply to. So I'm just kind of conflicted on that one. And I know I went through the rules process with you here, that it is a long process. But rules are promulgated after the legislative intent is pretty clear, after the statutes are in place and have to carry out the statute's not in place. And we're doing rulemaking prior to all of that. So I'm really looking at, I'm intrigued by give us time, give us the flexibility, and looking to guardrails from us, and rulemaking may be a little presumptuous, and starting with rulemaking is usually at the end of the process. And we're jump starting it by just doing rules. I'm not sure what we're doing rules for. Sean?
No, I'm all set.
So I'm just processing through, Karen, about the flexibility, give us the guardrails, let us coordinate within the agency to figure this out. Because I think by doing that might help in terms of where's the governance of all this. Maybe what we need to look at is a governance structure that might then help us figure out where the placement should be or where that facility should be. I think the governance issue is a big issue because the way the bill is drafted, it's only the Commissioner of Corrections. And then there's some consultation with the other departments in the agency. But it's really the driver is the Commissioner of Corrections.
I think that's where I have some concern, right? Because I agree with having time to think and like maybe envisioning a separate facility and everything, but the Commissioner of Corrections is at the helm of doing all this research. And when I hear the commissioner, and the committee can correct me if I'm wrong, when I hear the Commissioner of Corrections testify, it feels like he's got a pretty strong idea of how it's going to go when he's talking about specific units like Alpha and Bravo. It doesn't seem like he's envisioning a separate facility at all. So I just wonder if we already know how this movie's going to end.
Just putting some thoughts out, Karen.
Yeah, absolutely. May I respond? I have two thoughts.
Sure.
So one, I think when we initially proposed the interim report language, we had the part in there about the report would talk about the status and anticipated timeline for adoption of rules. And I think maybe what's confusing things is, and we had talked about the effective date being July 1 of 2026 wasn't feasible. And so Katie went through and kind of tried to tease out the different effective dates. And so, I don't think we necessarily meant to say that we're going to have rules ready starting in July of this year. I think she thought that
That's not what I'm saying. I'm saying beginning July 1st, you start the process of promulgating rules. And you're starting that process of promulgating rules, not knowing what the facility is going to be.
Right. So I think what we meant to do is to say in the interim report, we wanted to come to you with an update of what we think would be in the rules and the timeline for that. And the way she did the timeline makes it sound like we're going to start on July 1 to actually promulgate the rules. And I think that date was really just to start like that provision going into effect that we needed to think about it. All that to say, I'm fine with you making changes to that because I think really what we're talking about is how do we flesh something out, and rulemaking, you're right, can't really start until we flesh that out. And so the idea was not that we kind of get that concrete that quickly. And to the other part of the other concern, we had asked on the Senate side and continue to say here that I think it makes sense for it to say AHS is going to submit the interim report and AHS is going to lead the rulemaking. I think there was an idea that it would make sense to lay out all the different departments to show that they were included, but I think we all know that AHS does include all those departments. So that is something that I had actually later on in testimony, but to talk about things that might address some of your concerns. And so I think making it really clear that AHS is holding some of that work to ensure it's all of the commissioners and departments coming to the table makes sense.
Okay, great. Anything else before Karen goes on? Okay, Karen, oops, did you have something? Okay. It's all yours again, Karen.
Okay. So now I just wanted to spend a little bit of time on kind of what happens now, because I think in all of the details, sometimes it gets lost as to what exactly we're trying to do here. So I can talk about it from the legal standard, and if there's questions about the clinical issues, Ali is here and can answer those. But in terms of what happens now, so who are we talking about, right? We're talking about people who've been found incompetent or insane. And so the way the process starts is if there's a concern about competency, a judge asks for an evaluation. There's someone that from a designated agency that makes a determination about whether or not they think that could happen on an inpatient or an outpatient basis. That goes back to the mental health standards in terms of danger to self or others due to mental illness, and do you meet the clinical criteria of being in a hospital? And so right now, if the issue is mental illness and you meet hospital level of care, then you would go into a hospital and you get treatment, and you'd also get your evaluation there. If it is mental illness, but you do not meet criteria for inpatient hospitalization, then your evaluation would occur on an outpatient basis. So that could be in corrections or in the community, depending upon your conditions of release. If it's not mental illness, it's substance use, TBI, dementia, intellectual developmental disabilities. The hospital isn't an option. So those are all outpatient evaluations. So if someone gets the results of their evaluation, the evaluation is then shared with the state's attorney, defender general in the court, and the state's attorney or defender general can decide, I don't agree with this report, I'm going to get my own. Sometimes everyone stipulates to what the report says. Sometimes it's a contested hearing. Ultimately, the court makes the decision about whether or not someone is competent. That would be the same under this model. But just to be clear, it's other people can get evaluations outside of the DMH contract. And again, DMH staff don't do these evaluations. We are not a party to criminal cases. We simply by statute hold the contract, but we don't, that's all we do is we just have a contract and we organize these things. So if someone is found not competent, then what's, oh, sorry, I think I see a hand.
I think we have a question.
Who does that evaluate? Who do you contract with to do that evaluation now?
We contract with a company called Novotel. Actually, they might have changed names. They used to be a Novotel, but we contract with an organization.
I just want to be clear, so, because I kind of lost the thread here. So if someone is not competent or the judge has ruled the person needs an evaluation for competency, it's due to substance use. It's not due to a mental illness. They have an outpatient, non-hospitalization order. And who the person could, at that point, depending on, it'd be a criminal charge, depending, they could be held as a detainee in a correctional facility, or they could be out in the community. That will be up to the judge to determine, as they would with anyone coming through with a charge. But the layer is, there needs to be an evaluation of competency. So does DMH contract out to do that evaluation? You do?
Yes.
So if the person has an outpatient, non-hospital order, and the judge determines that the person should be a detainee in a correctional facility, where does that evaluation and who does it in that situation?
So it's still our contractors, and we would work with DOC to arrange that evaluation, and it would happen in corrections.
And it would happen in corrections by the entity you contract with.
Yes,
And then that entity you contract with would then make the determination if the person was competent and submit that to the court.
yes,
And DOC would not be involved in any of that except for housing the person.
correct.
Not as the bill currently is written. The bill does place the DOC as the people who are in charge of doing that evaluation. It does not articulate that the agency is.
Right. I mean, that's why I wanted to find out what currently occurs, so we know what currently occurs, and then what the language in the bill is proposing. So they're proposing a forensic director, and the interpretation of that is it would be through WellPath, which is the contractor for DOC to provide healthcare and mental health care in our facilities. So that's the shift that occurs in the language.
So I
right
would
now-
point you,
Karen?
oh, sorry.
Oh,
I
go
would
ahead.
point you to page 14, section 2, where it talks about the evaluations required by this chapter may be conducted pursuant to contracts entered into between the Commissioner of Buildings and General Services and evaluation providers. So I don't think the idea ever was that it would be WellPath doing these. So right now DMH does them, and we're fine to continue to allow our contract to do it. What there was discussion about on the Senate side was that we have a contract with these evaluators, but if the state's attorneys or defender generals want to use them for testimony, they have to contract with them separately. And those rates are often much higher because there's not an economy of scale. And so what we talked about was maybe BGS holding a statewide contract that everyone could tap into and use as they need to, kind of like other contracts we do. So I don't think that the idea was ever that, but I understand why it's confusing. And so I think there's a way to add language that talks about other providers doing these evaluations, because that was at least my intent.
On page 14.
No, it's not on page 14, it's on page 11.
11.
Oh, I'm sorry. Am I
No,
looking at a
that's
different
fine.
version?
That's
Apologies.
Um,
Can I just ask a quick clarifying question there?
yeah, but it's in conflict with what's just on page 2. Anyway, yeah,
Karen, what prevents the state's attorneys from, is that HIPAA that prevents them from accessing that? Like, as we consider whether or not BGS holds a more broad contract for these evaluations, what is in the way right now from those evaluations being shared? If DMH does the evaluations now and the state's attorneys want the results of that evaluation, what's in the way of that being shared?
Oh, no. Oh, they do get those evaluations.
Okay, then I misheard something then. Can you state it again? What would be the rationale for moving to a BGS holding of a broader contract?
Because right now DMH contracts with these independent evaluators, because by statute we're responsible for the neutral evaluations. Sometimes though, and we only contract for the evaluations. Sometimes the state's attorneys or defender general, depending on how the evaluation came out, wants them to come into court and testify. We don't pay for that. And so they have to have a separate contract with that group to pay for testimony. And what we find is sometimes they're getting charged higher rates because there's not that economy of scale. And so the idea was, it's not super relevant to this other than it's something that we contemplated because we never really assumed it would be WellPath doing these, at least from our perspective, is that there would be a bigger contract, just like other services that BGS holds now that the state can tap into. And so DMH would still continue to do our part of it. We would just pull from that bigger contract. The state's attorneys could pull from the bigger contract, but we'd have much more consistent rates and ideally save some money.
Is there
Does
any
that answer your
language?
question?
It does, thank you. Is there any language that's been drafted in and around that sort of contemplation?
So we started to in the Senate side, but what we realized is we don't actually need language, right? The state can just contract for it. It's more of we need to work together as a state to figure out how we want to put out an RFP and then how we want to make sure that everyone can pull from that statewide contract. So we don't actually need language. We did have some initially and then we pulled it out.
You don't think it would need to be in statute?
I don't, because it's still it would still be DMH being responsible for the neutral evaluations. I think in here, what you could say is, you know, under the evaluations that they must be conducted by a separate contractor than the contractor providing services within the facility. But it doesn't need to say that BGS holds the contract, because it could be DMH that holds the contract and we let DOC use it. We're just kind of determining as a state what the best way to contract is more efficiently, because I think we could make changes. Does that?
It does. I may come back to this in case I feel like I have it right now. But as we start getting into language development and everything, I may need some help down the road.
That's
Yeah,
true for all of us. We have another question, Karen.
I guess a comment, I guess maybe, is what you're saying, Karen, sounds good to me. Except a lot of the language is kind of like may, you know, where we kind of do this. And from some of our perspectives, whether we're overthinking it or not, I mean, I'm willing to give the grace that that's a possibility. May doesn't equal shall, and that concerns me. That, you know, just because maybe currently you do it a certain way, doesn't mean it will happen a certain way. And I think many of us have concerns that the may can go away, I guess, and we would like a shall of some sort, if that makes any sense to you. But I feel like I need a more of a guarantee. Maybe I'm completely wrong that it will happen this way. And that I don't have to be concerned about. Anyway, I leave it there. Connor just shook his head, so I get nervous.
no, I don't disagree with you. And I had drafted some language, but clearly I'm not in front of you, so I can't show it. But it said must be conducted by a separate contractor. So I think that's totally fine. I don't disagree with you on that. We also don't want an appearance of a conflict.
Right, that's my concern.
DMH, that's fine with us. And I apologize if I didn't make that really clear in my testimony.
So if there's a contract out there for the evaluation, right? And I guess right now, who determines that the person, this is current. You contract out, you have someone go away, and the person's being detained in a correctional facility. The evaluator has done the evaluation and assesses that the person is competent to stand trial. So they've made that determination. And then they submit that to the court. So the way that the
and just to be clear, it's just a clinical recommendation, right? So in their clinical opinion, the person is competent. Yeah.
Okay. So the way the language is written, upon the determination of the forensic facilities clinical services director. So the way the bill is written is clinical service director that makes the determination that the person is competent and then relays that to, I believe relays that to the Commissioner of Corrections to then relay that evaluation to the court. So the facility clinical service director, who would they answer to under the bill?
Yeah, so sure. So I think that's something that hasn't been fleshed out yet. I mean, they would ultimately report to DOC, whether that's a contractor or employee. I will say that one section is something that we have flagged in House Judiciary as confusing. So initially the word was likely competent. And so I think the intent of the language, which I think is not clear and needs to be clarified, is that, you know, when someone comes into the facility, it's because they've had an evaluation and they've been determined by the court to not be competent. the language calls for someone to be reassessed every 6 months. And so I think the idea is that if an assessment came back that someone was likely competent, that then the director of the facility would let DOC know that to then let the court know, so then the court could have a hearing. I get that that is not clear and really needs to be clarified, but that was the intent of the language. It was not that they're determining it, but that they are getting information from an evaluator saying we think they're now competent, and then someone needs to let the court know. But I agree that that's really confusing and can be written better.
Kevin?
Who's in a position to ask for an evaluation? Isn't it to the
I'm sorry?
defending attorney? Who
So-
is in a position to ask for an evaluation for competency? Isn't it the defending attorney? Maybe that's the wrong term, but
Yeah, so if you're in, so now anyone can ask for it. If you're in the facility, the way that it's drafted is that you automatically get reevaluated every 6 months. However, in between those 6 months, you're right, the defendant or his attorney could say, we think that there's been a change, but right now in the facility, it's an automatic every 6 months.
right. So they get the information, they bring it to the court and say, we're presenting this to the court because we believe the individual we're representing is not guilty based on insanity or incompetence. And the court makes a decision. Isn't it that straightforward?
Yes. I
Okay.
mean, from our perspective, and I get the language isn't super clear that was the intent.
So you're talking, Kevin, about Bill, you're not talking about current process.
Oh, yeah, I guess I don't know what current process is. I would, no.
I mean, that's the same. Yeah, I would say it's the
assume
same.
it's the same.
Except,
I mean,
yeah, you don't get automatic evaluations every 6 months now because we're not restoring people to competency. You know, there's language that was passed a few years ago that says they only get a new evaluation, at least that DMH pays for, if there's reason to believe that the person's clinical presentation has changed. Because if it hasn't, there's no point in doing a new evaluation. Several years ago, we made changes to the statute to put that in there because we were seeing people we were getting requests for the same person to have 4, 5, 6 evaluations, and they were all not competent because we're not restoring, and that was a huge waste of time and money. But this is different. It does make sense to reevaluate them regularly because they're actually getting programming to restore them.
Other questions on this piece?
bless you.
Tom.
Thank you.
Anything else, Karen, that you wanted to share with us? Just looking at the time.
Well, so I just wanted, so we didn't super get through it. So I just wanted to clarify so that's how someone would get an evaluation. And then if they were found not competent, the statute says that then the court needs to have a hearing to determine whether or not DMH or Dale custody is appropriate. And so the court says they can be held for up to 21 days.
This is
in
current or in
This
the
is
proposed? Okay,
This is current, because I just want to again highlight the gap. And
okay,
so
so go over that again, so we can shift our brain that this is what currently is occurring.
yes, okay, so currently, you get the evaluation, DMH does the evaluation, it then goes to the court and the parties decide if they want to get their own evaluations and contest it, or if they want to stipulate. Ultimately, the court makes the final decision. If someone is found not competent by statute currently, then the court has 21 days to hold a hearing. And the person can be held in corrections during that to determine whether or not DMH custody is appropriate, Dale custody is appropriate, or there is no custody that's appropriate. And so this is where the gap is. So if someone is appropriate for a hospital level of care, then they would be ordered into the custody of the Commissioner of Mental Health, and we would hospitalize them. Frankly, if that's where we're at, they're probably already in the hospital, but that's the option, right? And that's a secure setting. If it is mental illness that is the cause of the incompetency, but it's not acute enough to need a hospital level of care, then the individual would be released into the community under an order of non-hospitalization. If the reason for the incompetency is substance use or TBI or dementia, there is no custody available for them. So again, they would be released into the community. If it is an intellectual disability or a developmental disability, Dale under Act 248 is a potential, but as you heard, I think from Commissioner Bowen, I believe it's only for intellectual disabilities, and it's a pretty narrow group that's eligible for custody. Even if they were able to go into Dale's custody under an Act 248 orders, those are not secure settings. So all this to say, if someone is found not competent currently, there's really only one secure setting that's an option, and that's the hospital. And you can only go into the hospital if you need hospital level of care. And so what we're trying to address is that gap, because there are individuals that don't meet hospital level of care, or maybe they do initially, but you don't stay in the hospital forever, just like if you go in for a medical issue. As soon as you can be served on an outpatient basis, you are discharged, right? We are an acute hospital, and we don't keep people. So even if they start in the hospital, they will not remain in the hospital. And so that's the gap, because you don't have secure settings. And so what we're trying to target is only those that have been accused of committing the most heinous crimes like murder and have clinical needs and have been found by the court to be in so much of a danger to the public that they need a secure setting. And so that's the gap, because we don't have that now. Those are folks that are not able to be served in a secure setting or not in the community. So I just wanted to help clarify again what we're talking about in terms of the gap and the legal structure currently.
So let's play this out. So there is a person, this is current. There's a person who comes in with a criminal charge. It's one of the big 13s. So it's one of the big 13 listed crimes. Most times folks on that level are usually, if they're not a flight risk, they're usually, if they are a flight risk, bail will be set, and sometimes, a lot of times they are detained. That would also occur for someone who needs a competency evaluation, correct? Correctly.
Yes.
So they could have a high bail amount set right now. Severe crime that they've been charged with. And they would be incarcerated as a detainee. There is an evaluation that would be done where DMH contracts out with an entity to do the evaluation. That goes back to the court and the parties, and then it's determined that the person is not of hospital level care, but is non-hospital care. So then what happens? What does the court decide then in that particular situation? Person hasn't met bail, there was a high bail, the person hasn't met bail, they're a detainee. Does that person stay in a correctional facility now?
For a certain period of time. And so the way the statute is written, it says they can remain in corrections for up to 21 days. I think that we have seen some courts say that means after 21 days we have to release them even if there's not a good option. I think we have seen some courts try to get creative, especially in some of these really heinous crimes, to try to figure out if there is a way to kind of ensure there's a secure setting for an individual. But our statute does put a timeline on it currently.
Of 21 days, but that 21 days, isn't that the 21 days that the court has to make a decision?
Right. And so
by that 21 days, the trigger is the court has to make a decision.
yes.
So it doesn't say that after 21 days, the person could be released.
I think some courts interpret it that way.
Okay.
She's got an issue, right?
And I think that's part of the problem, right?
Yeah.
Is that
Yeah.
you can't continue to indefinitely hold someone who's not competent if you're not giving them treatment. And right now, because there's not a structure to provide that treatment, you can't just keep them in corrections. And so, what we're trying to build, right, is that treatment setting.
All right.
So Karen, can I get your interpretation on why does incarceration, housing somebody in a correctional facility, suddenly become considered not incarceration when we apply treatment, right? We're being asked to consider adding a forensics treatment, which everybody agrees needs to be in place. I'm sorry, do you understand? Maybe you already understand my question because I don't know if I've articulated quickly, but we're saying that just the introduction of treatment suddenly transforms a correctional facility from incarceration into a treatment facility, thereby getting us out of that 21-day.
Interpretation.
Yeah, that I don't. This is at the core of my concerns with this bill, is that suddenly we're saying, right, we've housed this person for, let's say, 15 days, pending a determination from the courts as to whether or not they're competent. We're edging up on 21 days. Plenty of court cases have indicated you can't keep them incarcerated. The bill suggests that, oh no, it's not incarceration now because treatment is involved. I can't get there. Can you help me?
Yeah. So, and just to be clear, so at this point, the court has already determined that they're incompetent. The decision is whether or not the
Thank you.
21-day
I'm with
timeline is
you.
about custody. Yeah. Okay. So I think and I'm not sure if you've heard from Jared or Kim yet from the state's attorneys, but this language is really mimicked from the federal system. And I think there's federal case law talking about how you can't hold someone indefinitely, and I believe even the ACLU, you admitted this yesterday, right? Like you can't hold someone indefinitely unless you're providing treatment. And so this is different. What we are proposing is different than what happens now, right? Because right now they're just being detained. And, DOC does provide some level of services, but what we're talking about here is a much more intensive focus level of services. And so I do think that is the difference.
And that's enough to, your interpretation is that the introduction of that treatment is enough to no longer consider this incarceration.
I believe, based on everything I have read and in consultation with the state's attorneys, that this is a constitutional approach. Again, there's due process built into every step of this, and you can't be held there if the court finds there's a less restrictive setting for you to be in. That is part of the analysis, right? Like the idea is that you're getting this kind of focused treatment because you are a public safety risk and you have a treatment plan and you have goals, and those risk assessments are really going to help determine what an individual needs to remain safe and what they need to work on to be able to go into the community and maintain that safety. The idea is not that someone is there forever. It's really, how do you identify what's causing them to be a risk, and how do you help make sure that you can mitigate that to the best of your ability in the community? Risk assessments are not, you can never always predict violence, but the goal is to make sure that that's also a consideration along with treatment.
Thank you.
Does that answer your question?
Well, yeah, it answers my question for now. It doesn't answer my overall concerns. And that's not your job, but yeah.
It's our job. Kevin?
How long can an individual who's been charged with murder be held without standing before a court and being judged as guilty or not guilty?
6 days.
You mean if they're not competent or
Nope,
they've received
just
right now?
right now.
It depends, it could be 2 years.
Well,
Okay, my
but
point is, my point,
statute is somebody being held without bail has to have a trial within 60 days. That's not
Right,
currently
that's-
being met.
Okay,
That's not
60
currently
days.
being met.
so the reason I asked the question is because we're now talking about a subset of those people where the defending attorney says, but he's really not guilty because he was insane or or he's incompetent to stand trial. And the way I'm understanding this is in fact tightening it up so that that person needs to be evaluated within 21 days to see if in fact that's true. So this is actually an added benefit to the people who might fall under the situation of insanity or incompetent compared to those where that isn't their defense. So this is actually adding value to these people who may be insane or incompetent. If they don't have that kind of a defense, they can be held for 60 or whatever days because they've been charged with one of the 13 offenses. This would
Yeah, I
allow
think
them not only to be evaluated, but if they're evaluated and found incompetent or insane, they actually can get some help. Whereas right now, they don't.
I don't
And-
disagree with anything you're saying.
Okay, and because we're expediting this evaluation, we're protecting the public because we determine whether they in fact really are a danger or can be found. Yeah,
We still have the question though of where they're being held once determined either not guilty or incompetent.
Right. It's not
Right.
guilty, it means
Yeah.
you're not guilty.
And we're housing them in a prison.
I think one
That's
of the
still
things that
remaining question.
well, but they'll either be in the hospital because they're clinically necessary, or they will have a different program, which is outpatient or whatever. That evaluation will happen more quickly than if they.
I don't disagree. That's
So-
a good part of this
so-
bill.
Right, so that's the value here.
The question is who has the control and where are they housed? And in general, population of corrections may not be the appropriate place if someone is not competent to stand trial.
And the court still has the control, it's the judge, based on an evaluation of an outside agency, which is not
But we're not
swayed
sure
by
about
DOC.
that. The
Well,
way the
okay,
language in the bill is,
Yeah,
we're not
that's
clear
true.
it's an outside, it could be DOC doing the evaluation. That's where the conflict.
we
So,
could tighten that up, yeah.
so Karen, you wanted to weigh in?
Well, I was just going to say two things. One, I think that, other states call it guilty by reason of insanity. And even though it's technically not guilty, you don't get to that phase. And I think the state's attorneys do a really great job of talking about this. Unless they have proved beyond a reasonable doubt that the person has in fact committed the crime, it's an affirmative defense. And so I think that's just important to keep in mind, right? And then in terms of whether someone's incompetent and should be in general population, I would say that is happening now. So if they are being held in corrections and they're doing a competency evaluation, they are, depending on where corrections is determined they need to be, they could definitely be in general population. The other thing I just want to note is that a competency evaluation, competency is a legal standard, not a clinical standard. And so when someone gets a competency evaluation, that's not treatment, that's not an assessment, that's not a determination of what they need. That's simply, can they participate in the court process? And so I just want to make that clear too, because I think sometimes there's a misunderstanding that if someone's getting a competency evaluation, that equates to treatment, and it doesn't. It's simply about whether or not you can participate in your trial. This program that we're proposing would give them that those clinical services and do different evaluations to determine their needs, which they are not getting now when they are held and waiting for competency evaluation.
So Troy, and then we're gonna have to close
Yeah.
up because we have to get on the floor.
So Karen, no disagreement. Two things though, just because it's currently happening now, for me, is not rationale for continuing to do it, right? I am suggesting that because it's happening now is problematic, housing these folks in Gen Pop. The other thing I want to just be really clear about is we are not talking about guilty but insane. We are talking about the Vermont standard, which is not guilty for reasons of, if you want to initiate legislation that brings guilty but insane into the Vermont statutes, I will partner with you on that. But right now, we are being asked to consider what we're doing with people who have been found not guilty. That is a complete defense. And we are talking about keeping them in jail nonetheless. So I don't want to cloud the fact that on those two matters. Just because we're doing it now doesn't mean it's good practice. We are not talking about guilty but insane. We are talking about not guilty for reasons of insanity. And those are two separate things. We do not have the option to find people guilty but insane in Vermont right now. Happy to have that fight, join that fight with you.
And I guess what I would go back to is Commissioner Haas' testimony the other day, which is that these are folks who are in corrections, are not at the acute stage of their illness, whatever that
Understood.
may be. And so general population may be very appropriate for them. So I don't want to prejudge that
Understood.
because those are
Yep.
decisions that are clinical. Yeah.
Yeah,
Thank
I share the concerns about isolation. Absolutely. Yeah.
We all do. That's why if we go forward with anything, we want to make sure we're doing it right. And we may have a whole different model in terms of governance, because I think governance is the real issue. And the other issue is, should there be a separate unit, separate wing, or even a separate building within a secured facility? And who governs what happens within that wing or within that small facility?
Mhm.
That's the constitution that we've got to resolve. And other committees are weighing in on this. There is a new draft. The House Judiciary came out, it's draft 1.1.
Doesn't get into the corrections piece.
No, they're not in the corrections piece, but they're in the legal, the front end for them.
Yeah.
And also the victim notification, they're working on that as well. But that's all kind of tied into how we go forward with the DOC piece.
Mhm.
Healthcare and Human Services, I'm gonna start taking a look at this, I hope next week. They had a walkthrough. Human Services had a walkthrough yesterday. The 4 chairs of the committees that are getting together Tuesday, 11:30 to talk through how this is gonna all come together. And we'll have better direction then. And I'm gonna really welcome the input from our Healthcare Committee and Human Services Committee, because I think they have some real thoughts that may be beneficial for us. So we need to get on the floor. Karen, I want to thank you for coming in on Zoom. Enjoy your trip. Enjoy being in warm weather. And don't feel obligated to do a lot of work during the upcoming week. I want to thank you.
Thank you.
for taking time
Thank you,
today.
Karen.
Yeah.
Of course, yes. But if you have questions, feel free to reach out.
Will do. And then I want to thank
Thank you.
you who are sitting here. And I know this is the beginning of vacation for some of you, and don't feel you'll have to connect with us next week. Enjoy your Costco trip. So let's go off live. We will be back here after the floor. And do we have